So on this slide here, I'm going to list all of the misconduct and malfeasance that towards me, the public and taxpayers, by District 7 and Pasco MPO. So it's just a summary of all of the things that they've done that I accuse them of being misconduct and malfeasance. So I'm starting here with knowingly and intentionally they've committed breach of public trust. So for the MPO board members to meet privately with PD&E study consultants to discuss alternatives in which false information was exchanged. Well, it doesn't matter that it's false information was exchanged. The fact that the board members met privately with consultants is a misdemeanor in the state of Florida. I mean, it's illegal. It's unethical for them to do it. But that is what Commissioner Starkey is admitting to at the one board meeting when she and Gwen have a laugh at the PFI, and by extension me, as being crazy. Well, she's meeting privately with consultants, which is unethical and illegal. District 7 misrepresented the US 41 SR 54 project purpose and need to meet projected traffic demand, making this a capacity project when in fact it's an economic development project. So the purpose and need is to meet future traffic demand. That's level service D. The SPUI does not do that. It's level service F. So they're not satisfying the purpose and need of the project, but what they are satisfying is the MPO board's desire to turn that road into a freeway and to facilitate economic development in Port New Richey and Port Richey, and in Commissioner Starkey's district. Okay, I can't see that project as anything other than economic development project because they have shown zero interest in eliminating congestion on 41, which the PFI does. They don't care at all about US 41. Knowingly, intentionally committed breach of fiduciary duty, given that the district and MPO are not acting in the public interest. All you have to do is look at how the two compare side by side, SPUI and the PFI. You know they're not acting in the public interest. The fact that the SPUI is going to mean that it costs the public $100 million a year, by my estimate, by their estimate $48 million a year, but of course their estimate's wrong. $100 million a year, the SPUI is going to cost the public in lost time and excess fuel consumption. How is that in the public interest? You know, and it also is impacting the community with the visual impact of the structure, access, etc. And then the MPO and District 7 are not acting in the taxpayer interest. That's objectively true. The PFI saves the Treasury over $60 million in project cost and life cycle cost savings. So that's an objectively true statement there. You know, what is the justification for them to spend so much more money? Well, I'll get to that. District 7 MPO designed the PFI improperly to be falsely negative. So they didn't follow my specifications. They designed the PFI to fail and be stupid. That's okay. That the District 7 MPO analyzed the SPUI improperly to be falsely positive. that the District 7 MPO provided the public with false and insufficient study results. So they omit information from their study results that in turn causes the public to have an incorrect opinion formed. I mean, this fiduciary duty, what I'm calling breach of fiduciary duty, is also fraud, which I'm going to get to. The MPO canceled the Vision 5456 study before District 7 could report the PD&E feasibility study results to the task force as agreed. This is a deliberate sabotage because the task force had voted the PFI and not the SPUI as their preferred alternative. So this is where the MPO board, doing damage control basically, because of me correcting the disinformation that was deliberately given to the task force to manipulate them, I correct that with my emails before their vote, and then they vote, and the PFI is voted number one. Well, the MPO board, they're going to put an end to that. So they just cancel the study and dissolve the task force, and then FDOT is just does a public meeting. They don't go back to the task force where I have an opportunity to have a voice. So this is all about killing my influence, killing my ability to correct the record. Knowingly and intentionally committed breach of contract, given that with respect to the agreement between FDOT and their consultants, the public and taxpayers are incidental third-party beneficiaries, and I'm a primary beneficiary by virtue of the PFI explicitly included in as an alternative. So I'm not an attorney. This is my opinion. So, but this is how I see it, is that the contract between FDOT and their consultant, that binds both of them. If you read their contract, and I will touch on it later, the language binds both FDOT and the consultant to follow the PD&E process, FDOT's PD&E process, and all relevant regulations and policies and pertinent law. Okay, when they, so any contract between a government entity and a consultant, I believe, I don't know what the legal principle is, or if there's some doctrine, don't know. Honestly, I don't care. I know that the courts and the legal system of the United States is corrupt as hell, and it's interpreted in such ways that always seem to favor the state, and that lawyers are themselves captives of state interests. They are all creatures of the state. So anything that benefits the state is how state functionaries like the courts and judges and prosecutors, they're going to interpret the law always as it favors the state. Of course. The Supreme Court is generally, not always, there are exceptions, but generally is going to interpret law that furthers the interests of the state against the people, because they are agents of the state. They have a conflict of interest by virtue of the fact that they are functionaries of the state. Okay, they can't be considered independent actors, even as they are deciding on whether a law is constitutional or not. So I don't know the legal doctrine behind this, but I believe that the public and taxpayers are the beneficiaries. They are incidental beneficiaries, third-party beneficiaries to any contract between the government and a consultant or private party. The government itself cannot be the sole beneficiary, because the government itself is allegedly presumably acting in the interest of the public and taxpayers. Now, my experience on this project is that these bureaucrats at FDOT and the Pasco MPO, they're acting in their own selfish interest. They're not acting in the public interest. They're not acting in the taxpayers' interest. But the contract that they have with their consultant, I believe, is that makes the public and taxpayers incidental third-party beneficiaries to that contract, which is why I believe they both have to perform on their contract. That if they fail to perform on their contract, to do what they are obligated to do per the written contract, that they are harming the public. They are harming the taxpayers. It's not a contract where the DOT is a beneficiary, and if the consultant doesn't perform, then the DOT is harmed. That's not the way I see it. The way I see it is they both have to perform. If the consultant fails to perform on that contract, yes, the DOT is harmed by that, but so is the public, and so is the taxpayers. I don't see how it could be any other way. And because it's a two-way contract that obligates the DOT and the consultant, if either of them fail to perform on that contract, they're doing harm to the public. They're doing harm to the taxpayers as incidental third-party beneficiaries. I become a primary beneficiary when the PFI, my patented PFI, is added as an alternative, which it was for the feasibility study. They have a contract with the consultant, which I think is an amendment to the original PD&E contract. But when they entered that contract with their consultant and the PFI was an alternative, that made me a beneficiary of that contract. Because if the PFI is selected, I get my fee. They are obligated to perform that contract. And if they fail, either of them fail, I believe it's a breach of contract that harms me. I can't get an attorney. No, I can't sue them because they have sovereign immunity. So I'm screwed, but I think in principle I'm right on this. But there's no attorney will represent me. I've spoken to attorneys. I've contacted many attorneys, and none of them, most of them, almost all of them, don't even respond to me when they know what I'm looking for. And the few that have responded have said because I can only hire an attorney on a contingency basis. It's only on a contingency basis I can hire an attorney. And none will do it because of the risk. And I don't blame them. I mean, if the state has sovereign immunity, that's one hurdle. Another one is by the amount that I would be seeking, like $57 million, because I feel like I've been cheated out of $57 million as a result of their misconduct and their malfeasance. That I'm seeking, damages $57 million, plus the attorney would get their fee, which would be a percentage of that, like 10 or 20% of that on top. Well, any amount of money to sue the state of Florida, any amount of money over $300,000 has to be approved by an act of the state legislature signed by the governor, if it's over $300,000 in the state of Florida. So not only do you have to overcome the sovereign immunity issue, but then also have to get it through the legislature and get the governor's signature. So, and if the attorney loses, You know, if my side loses, then they're out any money that they would get. If they lose in court, they might also then be required to pay the legal fees of the state. So it becomes just too risky for any attorney to take. I get that. So I can't sue them. But in principle, I know I'm right. And I don't care what any lawyer is going to say about it that says I'm wrong. Because lawyers, I don't trust any lawyer. Lawyers can't be trusted. Judges can't be trusted. Just, they're all corrupt as hell. So, District 7. The District 7 was scoped to complete the PD&E's feasibility study in 1 year. They took 4, without justification. I informed District 7 my patent would expire and delays could jeopardize my fee. They didn't care. District 7 failed to hold the agreed upon 20 public meetings, holding only 1. So this is in their contract with their consultant, that they're going to do 20 public meetings. Actually, one of those is that they were going to have a workshop with the task force. So they were going to take their results of their feasibility study back to the task force and have a workshop. Of course, that went away. But they only held 1 public meeting. They were going to hold 20. That's in the scope and contract with the consultant. And that matters because I needed the PFI to get exposure. That people needed to see the PFI in order to give the public a voice. By only having 1 public meeting, they basically denied the public their voice. Of course, it didn't matter because all the information they presented to the public at their public meeting was a lot of it was false. District 7 failed to perform the agreed upon feasibility analysis of the PFI, and after 7 years rejected the PFI with subjective and capricious reasons not supported by said feasibility analysis. So the contract they have with their consultant is to perform a feasibility study to evaluate the feasibility of the PFI because it's one of the alternatives. They didn't do that. No feasibility analysis was performed. They did an incorrect design of the PFI, not following my specs. They incorrectly signalized it, not following my specs. They estimated impacts. They estimated cost, and that's all they did. They didn't analyze the feasibility. So later on, when Gwen says, well, it's potentially confusing, there's no engineering to support that statement at all. Is it? Is it potentially confusing? I mean, everything is potentially confusing. So that doesn't even mean anything. Is the PFI confusing for the driver? There's ways to assess that. They did not do any of that. District 7 did not actually study the PFI's feasibility. Knowingly, intentionally acted in bad faith. District 7 and the MPO were prejudiced against the PFI from day 1, even though NEPA requires that they remain objective, all the while allowing me to believe the PFI would receive honest, competent, rigorous, and objective treatment. So, I'm a sucker. I'm a complete sucker because I bought into the lie. I bought into their fraud. To the con that they were going to actually be honest and fair and competent with respect to the PFI. As time progressed, and I'm sure that I was suffering from, a terminal case of hopium by this time. But as time progressed, it became clearer and clearer to me that they were not ever going to give the PFI an honest assessment. So they were dealing with me in bad faith from day 1. That email that I got from Chen saying, hey, we want to look at this PFI thing and it's important for us to consider new things. That was just a lie. All of that was a lie. The only reason I got that email was because at that time Byron was involved. That's the only reason. But the email itself was a lie, which is evidenced by the fact that Chen's first response is, let's look at the CFI and get rid of this guy, basically. Get rid of the PFI. District 7, the MPO failed to seek my technical advice or request information on the PFI over multi-year periods of the Vision 5456 Phase 2 and PD&E feasibility studies. So, yeah, not once did they contact me during either of those studies for technical information, for advice, for comment, for review, for anything. All of my communication with them over those years, I initiated. And my communications with them got increasingly more frustrated and more angry. District 7 and the MPO refused to correct their misrepresentations of all three alternatives after my repeated objections, which they either ignored or spuriously dismissed. Yeah, so they don't follow my PFI specs. They do it wrong, and then I complain by email. It's all by email. At this point in time, I'm only communicating with them by email, deliberately so, because I want it on record. In fact, it was a choice I made right at the beginning. I'm only going to communicate by email. I mean, once we got past the initial stages, and they got into the Vision 5456 study, I made the decision I was going to limit my communication with them by email, not because I wanted a record of their misconduct, but because I wanted to protect myself in the future when I was thinking, okay, I'm going to get a big fee one day when the PFI is built. I get my multi-million-dollar fee. Someone may claim that I was acted in an inappropriate way, and I wanted the email evidence that I didn't. So it was for my protection. But then, and now, the emails I have as evidence of their wrongdoing. It's all documented. Knowingly and intentionally committed gross negligence. Given. District 7 allowed the MPO to delay the project opening year 10 years, from 2020 to 2030, without justification, jeopardizing my fee with flagrant disregard. Yeah, I mean, as far as I can tell, I tried to get an explanation from FDOT and the MPO. Why is this being delayed 10 years? Talk to the hand. They're not providing me any explanation. But the delay occurred when the Vision 5456 study co-opted the PD&E. That when the PD&E was put on pause for that Vision 5456 circus, all of a sudden the opening year goes from 2020 to 2030. District 7 and MPO completely excluded me from the engineering of their respective PFI alternatives. Yeah, so when they did their engineering, I was excluded. I consider that gross negligence. I'm the expert, but my expertise I was completely excluded. I was allowed to comment and they just ignored or dismissed my comments. And as I said, they never contacted me with anything. And they end up doing theirs wrong. Knowingly, intentionally committed fraud. Given. District 7 MPO presented false PFI design analysis impacts to the public, which they did by not following my specs. District 7 presented to the public the geometrically unfeasible CFI as feasible, and the operationally failing SPUI as acceptable, while omitting the severe degree of congestion at the SPUI signal will experience by their own flawed analysis. So the CFI is not feasible by their own standards due to the railroad track. So they went ahead with a design of the CFI. I'm going to talk about it more later, but their design of the CFI has the railroad track going through the intersection, which is very unsafe to do. And in doing so, they're not following their own standards. And then there's the Leonard Road intersection that's just right there, and they don't have the minimum spacing between the CFI South Junction and the Leonard Road. I'm going to go into that more, but I consider that not feasible. I complained to them. They ignored my complaints. And then the SPUI, this has been a theme over 7 years. All of the congestion on 41 at the SPUI signal ignored, just omitted completely. Completely omitted by the MPO and by District 7. District 7 MPO improperly analyzed all the alternatives, i.e. no correction for unmet demand, falsely reported average delay for oversaturated movements, omitted maximum delay and maximum queues for oversaturated approaches. So there's standard methods of analysis that is used to estimate delay and vehicle queuing for these alternatives. Okay, so the software they end up using is VSIM in the feasibility study. That's now MPO, they only use Synchro, and Synchro grossly underreports delay for oversaturated conditions. They did something that was just straight up lying to the task force, and they completely lowball the amount of delay that SPUI will experience. And again, I complain, I'm ignored. Because they ignore me, I then send emails to the task force saying, hey, this is what's going on that they are not telling you. Okay. Well, FDOT does the same thing, but they're using VSIM. Well, there's a condition in VSIM that's called an unmet demand. And what that means is there's traffic that they run the model for an hour, and if there's any traffic left over that hasn't gotten into the model, they just erase. They ignore. That's unmet demand. So that's traffic that's not counted in their delay figure. So they just pretend like it's not there. Unmet demand. The traffic analysis handbook says don't do that. Correct for that. And there's a way to do that, which they didn't do. The level of unmet demand at the SPUI is over 30% in the PM and over 40% in the AM. So just think about that. It's like 40% of the traffic is just simply not being counted. And somehow that's okay. So I complain about that because the PFI should not have unmet demand at the PFI. If it's done correctly, there should be no unmet demand. And if you just, with the SPUI, eliminate 40% of the traffic, then it's going to compare a lot better relative to the PFI. It's like a magic trick. You just make all those cars disappear. So, but if you correct for unmet demand, then you're going to get a true difference between them in terms of delay and queue. They omit queue altogether. So the queue is how long is the line of cars that are stopped over the course of that hour, the maximum amount of cars that line up that are still trying to get through the intersection. That's the maximum queue. The maximum delay would then be the time it takes the very last car to get through the signal. The last car generated in that hour is at the back end of that queue. How long does that car take to get through? They omit that completely. Both of those pieces of information. That's fraud. District 7 and the MPO concealed impacts of said SPUI signal congestion. So if you have 3 miles of queue, that has a lot of impacts. And if you just ignore it, if you just pretend that there's no queuing at all, well, those are impacts that don't happen. So like access to a driveway, well, it's hard to get to a driveway if you're stuck in a 2 or 3 mile long queue of cars. But if you just pretend that queue's not there, which is what they've done, then that access is just peachy. District 7 MPO omitted several selection factors favorable to the PFI, such as vehicle safety, construction duration, air quality, and life cycle cost. I mean, those are all pretty standard selection factors that I would expect to see in a PD&E that they omitted. All of those favor the PFI. Like air quality. They omit air quality. Of course, if they had included air quality, they would have probably said it's better for the SPUI, because that's just the way they are. Lying just comes naturally to these people. But when you have 2 to 3 miles of queue, of stop and go traffic, versus the PFI that doesn't have any congestion, well, the air quality is better at the PFI. And that should be one of the selection factors. No. District 7 concealed from the public that the SPUI will not meet project purpose and need, and concealed that the PFI will. So the project purpose and need is the most important thing, because that's the purpose of the project. Duh. Which alternative satisfies the project purpose and need? Well, the SPUI does not. I mean, even by their stupid analysis of the SPUI, it still doesn't. They show it having 3 minutes of average delay, which they shouldn't be showing, because there's no average delay with oversaturated conditions. So that's a lie. But they still show 3 minutes. That's a level surface F. Level surface F is more than 80 seconds. 80 seconds or greater. Well, they're showing like 180, 200 seconds of delay. That does not meet the purpose and need of the project. The PFI does. Even with their stupid analysis of the PFI or their modeling, it still is operating at, I think theirs has it less than 80 seconds maybe. Theirs is wrong. The PFI should be at around 42, 47 seconds of delay. And that's an accurate average delay because it doesn't get congested. So that means the PFI satisfies the purpose and need of the project. The SPUI does not satisfy the purpose and need of the project. I think that should be told to the public. That should matter. But it doesn't to them. District 7 MPO ignored or dismissed all my technical input on the PFI and proceeded to present their incorrectly designed PFI to the public. Yeah, so that's straight up fraud. The PFI, for it to function correctly, has to be designed and signalized correctly. And I told them this is how it is, this is how you do it, and they ignore me and do it their way, and it fails. And then they use the failure that they induce as justification to reject the PFI. That's just how shitty these people are. District 7 failed to show any VSIM simulations of the alternatives to the public, which would show the severe congestion the SPUI signal will experience and the PFI as congestion-free. So they have the models. They have the VSIM models. They have the simulations. They should have shown these models to the public. And they should have made it a point of showing to the public the extent of the congestion that will occur at the SPUI signal as a matter of full disclosure. That the public should see how much congestion is actually going to result with the SPUI signal. Not doing that is fraud. It's lying by omission. Okay, and then they should have shown the PFI designed correctly, signalized correctly. It would show it as congestion free, and that is consistent with the SPUI does not satisfy the project purpose and need. The PFI does satisfy the project purpose and need. You could see it in the simulation. Traffic backed up for miles at the SPUI signal, AM and PM, and no backups at the PFI. But none of that was presented to the public at the one public meeting or at the MPO presentation that they gave in February. All of that was omitted. Knowingly and intentionally committed acts of conspiracy to commit fraud. Given District 7 Secretary Gwen serves as a non-voting member of the MPO board. Okay, so that's how it's organized. That's how apparently it's supposed to be. That he, as the district secretary of FDOT, serves on MPO board as a non-voting member. But it also means that he is part of that body. That FDOT and the MPO are in some capacity acting as kind of one and the same. District 7 and the MPO coordinated to sabotage the PFI alternative. So, I don't have smoking gun evidence of this. I don't have an email exchange per se, though I do have emails that, through my public record request, that have the MPO talking to the district and the MPO conveying information to the district that is false, that is harmful to me, and the district just being okay with that. This was after the Vision 54-56 task force they conducted their vote, and the PFI is the number one choice, their preferred alternative. The director of the MPO, at that time it was Casper, sent an email to District 7 saying that in essence saying that I inappropriately prejudiced the task force in favor of the PFI. Okay. This was done without my knowledge, behind my back, because again, these are mean girls. So Casper makes this claim about me to the district, and the district just is like, okay, because they don't respond, at least not by email, and I get no notification. The proper thing for both agencies would be to say, hey, Greg, you're trying to influence the task force vote in an inappropriate way. That's what District 7 should have done. District 7 should have said, okay, let's stop this MPO study here and now because it's having an influence on the PD&E, and let's get to the bottom of this accusation that this guy is improperly influencing this proceeding. That would have been the right thing for the district to do. And then give me a chance to defend myself, because if they had, that's when I would have said, okay, then let's go over all of the disinformation that the MPO staff is feeding the task force that I'm responding to, and that these emails are my only avenue to do that because I've been prevented from talking to the task force directly at the meetings. Okay, I was shut down at the meetings by the MPO and by the chair of the task force. Okay, how is it that my voice can be completely silenced when I'm seeing clear misconduct on the part of the MPO staff and their consultant? And it endangers my PFI, it endangers my patent fee, okay? It endangers the project. How can they be allowed to do that? And I'm not given any kind of platform to respond. Okay, that's how things should have gone. I should have gotten due process after being accused of doing this by the MPO director, but the district just let it go. Okay. Silence is consent. District 7 and the MPO board were present at the February 2023 board meeting where false information was presented by District 7, which I called out at the meeting and was removed by the deputy when I did. And both agencies just looked on in silence and then carried on with their fraud. Okay. So in that instance, I see that as conspiracy to commit fraud. They're both acting together in a coordinated manner. I was silenced when I called it out. Okay, that is conspiracy to commit fraud. So the following few slides, I'm going to cite specific statutes that I believe that these people, these individuals, are violating by their conduct. So, starting with Florida statutes. So I accuse the individuals I name under the headings corrupt public officials and corrupt public contractors of committing official misconduct under Florida Statute 838.022, which reads in part, quote, 1. It is unlawful for a public servant or public contractor to knowingly and intentionally obtain a benefit for any person or to cause unlawful harm to another by A, falsifying or causing another person to falsify any official record or official document, B, concealing, covering up, destroying, mutilating, or altering any official record or official document except as authorized by law or contract, or causing another person to perform such an act. Then 3, any person who violates this section commits a felony of the 3rd degree, punishable as provided in these sections under 775. So, end quote. So, there's no question that they have falsified information in order to justify the SPUI and discredit the PFI. That they have falsified report documents and report results. The consultant prepared, but the District 7 personnel and the MPO board members and staff are fully aware of, because I've made them aware of over and over again. So they know that they're committing fraud. And then obviously they don't admit to it. They're not going to stand up and say, yeah, we've committed fraud. I mean, people who do that kind of thing don't admit to it, do they? But they know they're doing it because I've told them over and over and over again by emails, it's all documented, and my appearances before the board, that this fraud has been committed. And they don't care. They don't care. Which makes them a party to it. And who are they doing harm to? They're doing harm to the public, they're doing harm to the taxpayers, and they're doing a hell of a lot of harm to me. Okay? Are they benefiting by it? Yeah, I think they are. I think that the MPO board members, their agenda is to enrich themselves by turning that road into a freeway. Building a bridge over 41 is the first step to that end. You know, what are they getting from developers and local business interests? You know, who knows? I don't know. But there's some benefit to them. Maybe money that's going into their re-election campaigns or into their bank account. I don't know. But it's all circumstantial, the evidence, but there's a lot of it, and it all points in that direction. And then Gwen and the DOT people, why are they committing fraud? Knowingly. Intentionally. Well, I'm going to explore the motives more later, but it could just be convenience. It's what would be called convenience fraud, where the benefit to them is getting out of doing something that they don't want to do. So the motives are speculative, but the conduct is objectively true, or misconduct. And of those accused public officials and public contractors who possess Florida professional engineering licenses, I also accuse of committing engineering misconduct under Florida Statute 471.033, which reads in part, quote, 1. The following acts constitute grounds for which the disciplinary actions in subsection 3 may be taken. And then I go down to the subsection E, making or filing a report or record that the licensee knows to be false, willfully failing to file a report or record required by state or federal law, willfully impeding or obstructing such filing, or inducing another person to impede or obstruct such filing. Such reports or records include only those that are signed in the capacity of a licensed engineer. And then this G, engaging in fraud or deceit, negligence, incompetence, or misconduct in the process of engineering, end quote. There's no question that they have reported fraudulent results in the study that were generated by their consultant, and that the district staff know full well, because again, I've been complaining about it for years with my emails that they dismiss and ignore. So there's none of them can say, oh, you know, if there's any fraud or deceit, well, we didn't know, or it was just an accident. You know, we're only human. No, that's BS. That's complete BS if they do. As part of the US 41 and SR 54 PD&E and Vision 5456 Phase 2 studies, District 7 and the MPO respectively did fraudulently evaluate the build alternatives. Both agencies engaged in deceptive practices to grossly misrepresent the SPUI as falsely positive, to grossly misrepresent the PFI as falsely negative, and to grossly misrepresent the CFI as falsely feasible. PFI feasibility was never evaluated by either agency as they are legally required under NEPA. Yeah, so FDOT did a 4-year feasibility study, but they didn't actually study feasibility. There was zero effort put into evaluating the feasibility of the PFI. None. Zippo. They did a crap design over my objections. They signalized it wrong over my objections. It generates crap results, which they just put into their evaluation matrix, goes into their study report, and then they show crap impacts to the public and the MPO board when they select the SPUI instead and reject the PFI. Continuing, I accuse these individuals I've named under the headings corrupt public officials and corrupt public contractors of committing fraud under the U.S. False Claims Act. 31 U.S. Code, Section 3729, false claims, which reads in part, quote, A, liability for certain acts, 1, in general, subject to paragraph 2, any person who, A, knowingly presents or causes to be presented a false or fraudulent claim for payment or approval, B, knowingly makes, uses, or causes to be made or used a false record or statement material to a false or fraudulent claim, end quote. So, for the same reasons that these individuals have violated Florida statutes prohibiting officials making false claims, they have violated the U.S. False Claims Act as well. Now, whether that happened, whether they are in violation of U.S. False Claims Act now or later, I don't know. I'm not an attorney, so I can't answer that question. I think there's no question that they've committed fraud. It could be that because they are Florida state officials, that does fall under the U.S. False Claims Act, that they are already in violation, but they will certainly be in violation of the False Claims Act when they apply for federal funding for the project. So they will have to justify to federal highways the project for funding. They'll use their documentation to do that. That documentation will be fraudulent. Continuing, according to federal highways, a state DOT or local public agency must, as a matter of NEPA compliance, that's National Environmental Policy Act, quote, rigorously explore and objectively evaluate all reasonable alternatives, and for alternatives which were eliminated from detailed study, briefly discuss the reasons for their having been eliminated, devote substantial treatment to each alternative considered in detail, including the proposed actions so that reviewers may evaluate their competitive merits, include reasonable alternatives not within jurisdiction of the lead agency, end quote. Okay, so none of that was done. None of this was done. So they did not rigorously explore and objectively evaluate all reasonable alternatives. They started out with no PFI or CFI, no at-grade option, only bridges. So they did not include all reasonable alternatives from the get-go. Then they end up including the PFI and CFI, but they did not receive rigorous or objective evaluation. They did not devote substantial treatment to either. They devoted zero treatment to the PFI. Zero. They did a crap design that was wrong with crap signalization. I objected repeatedly. I was ignored and dismissed. Then they did their impacts. They estimated impacts based on their crap design and signalization, and they estimated cost, and that's all they did. That's all they did for in a 4-year period. The PD&E manual, that's the FDOT PD&E manual, is FDOT's NEPA compliance policy guide, which states, quote, the build alternatives are proposed to address the project's purpose and need. Build alternatives should seek to avoid or minimize impacts to the environment, end quote. And, quote, alternatives should support the purpose and need for a project in accordance with all applicable laws and regulations through the balancing of engineering, environmental, and economic aspects, end quote. Okay, so none of that was done. None of that was done. The SPUI does not address the project purpose and need. The PFI does. They reject the PFI and they select the SPUI. The build alternatives should seek to avoid or minimize impacts to the environment. Well, the SPUI maximizes impacts to the environment. And the PFI minimizes those impacts, but the PFI is rejected. District 7, the MPO, and the respective consultants did knowingly and intentionally fail to satisfy the requirements of NEPA and falsified or allowed to be falsified the results of the PD&E and Vision 5456 studies to falsely justify the SPUI as the final build alternative over the PFI, and thus did knowingly and intentionally fail to satisfy the project's purpose and need by placing their own selfish interest over the public and taxpayer interests. Cui Bono. Continuing, I further accuse the MPO board member, Commissioner Catherine Starkey, and others, possibly, I don't have evidence, but that's not to say they didn't also do what she did, of violating Florida Statute 286.011, Public Meetings and Records, which reads in part, quote, 1. All meetings of any board or commission of any state agency or authority, or any agency or authority of any county, municipal corporation, or political subdivision, except as otherwise provided in the Constitution, including meetings with or attended by any person elected to such board or commission, but who has not yet taken office, at which official acts are to be taken, are declared to be public meetings, open to the public at all times, and no resolution, rule, or formal action shall be considered binding except as taken or made at such meeting. The board or commission must provide reasonable notice of all such meetings, end quote. So at the October 2022 Pasco MPO board meeting, Commissioner Starkey admits to meeting with the PD&E study consultant. I mean, she admits to meeting with somebody who is running the VSIM model. The only one I can think of would be the traffic consultant, likely AECOM, who also has contracts with the MPO and Pasco County. So during which she received false information regarding pedestrian safety of the PFI alternative, which she described as crazy. This meeting violates Chapter 286 of Florida statutes, aka Government in the Sunshine Law, or the Florida Sunshine Law. This meeting clearly colored her opinion of the PFI, but when I corrected this information at the January 2023 MPO board meeting, she denied she was referring to the PFI, but didn't deny the meeting. She and Secretary Gwynn were referring to the PFI in their October 2022 exchange because the CFI was never a serious contender for selection. Now, they were just laughing at the PFI, and me, by extension. But no official action was taken in her private meeting, so that should make it legal, right? According to Google Bard, no it doesn't. So I asked Google Bard, here's my prompt. Florida Statute 286.011 specifies any meeting at which official acts are to be taken. What if the board member meets with a consultant that doesn't involve an official act? Does the statute still apply? Google barred, yes, the Florida Sunshine Law still applies to meetings between board members and consultants, even if no official acts are to be taken. The law is designed to ensure that public officials are open and transparent in their decision-making process, and that the public has access to information about the important government matters. The Florida Supreme Court has interpreted the Sunshine Law broadly to apply to any discussion between two or more members of the same board or commission on a matter that will foreseeably come before the board or commission, regardless of whether the discussion takes place in a formal meeting or in a more informal setting. This includes discussions between board members and consultants, even if the discussions are preliminary or exploratory and no final decisions are being made. The only exceptions to the Sunshine Law are for meetings that are necessary to protect public safety or security, or for meetings between a board member and an attorney acting on behalf of the board. Therefore, if an MPO board member meets with a consultant to discuss project alternatives, the meeting is subject to the Sunshine Law and must be open to the public, even if no official acts are to be taken at the meeting. So, I mean, it's just a broad interpretation of the Sunshine Law. If they're going to meet with consultants on a project, okay, if they're going to discuss a project that's currently in study that is going to be before the MPO board, they have to make that a public meeting. This was a private exchange between her and the consultants in which she was told it would take a pedestrian 20 minutes to cross the road. I didn't know that had occurred. If I had known that that had occurred, I would have objected. Not that that would have mattered. My objection would have been ignored anyway. My opinion on the PFI doesn't matter, even though I invented it and I'm the expert on the PFI. They don't care what I have to say. But they're saying 20 minutes to cross the road, which is a big fat lie. And she thinks it's funny and it's crazy. Well, yeah, if it takes 20 minutes to cross the road, that is crazy. She doesn't stop to think, well, is there something wrong here? Why are they saying it takes 20 minutes? Did they do it correctly? Did you guys design the PFI correctly? That doesn't seem right. Hey, Mr. Parsons, you're the expert on the PFI and you're before us and you're saying that they didn't design it correctly. You know, what's that all about? We need to get to the bottom of this. No. None of that happened.